and welcome to the 7th installment of the New Mexico State Bar Foundation Modest Means Helpline Small Business Webinar Series. My name is Margaret Lorenz, and I'm one of 5 staff attorneys at the Modest Means Helpline. My nickname is Mia, so if you hear that, that is me. Also with me is attorney Maria Trujillo, who is an attorney with the Briones Business Law Consulting Law Firm. The Briones Business Law Consulting Firm is based in Albuquerque and works with businesses throughout the state. The Briones Law Firm strives to be your corporate counsel so that your business is compliant, protected, and well advised. Also with me is attorney Casey Daniel, the managing attorney for the Modest Means Helpline and legal services director for the State Bar Foundation. Attorney Casey Daniel will be our moderator during the webinar. If you have questions, please type those in the question and answer box. Casey will periodically pause the presentation to ask your questions. Also, if you have ideas or thoughts for future presentations, please put them in the question and answer box too. This presentation provides you with general legal information for purposes of providing examples only. Neither the Modest Means Helpline nor any presenters are entering into any attorney-client relationship with any attendees or viewers of this webinar. We won't be discussing specific situations in this webinar, so please refrain from asking specific fact questions. You can call our helpline with specific questions after the webinar, and if you are eligible, we can go into detail with you then. Additionally, income tax requirements, tax duties, and tax responsibilities are beyond the scope of this webinar. When it comes to small business, there are always tax considerations, so be sure to get the advice of your trusted CPA or tax lawyer. The Modest Means Helpline is a civil legal telephone helpline and attorney referral service of the New Mexico State Bar Foundation. The Modest Means Helpline assists New Mexico residents with incomes below 500% of the federal poverty guidelines. The Modest Means Helpline can assist in civil legal matters, including but not limited to domestic relations, landlord-tenant, small business, consumer, and probate issues. This webinar is entitled Essential Contracts for Your Small Business. Contracts. Just the word evokes all sorts of not so fun visions. I'm here to try and change your mind. So you've taken the plunge, you've started a business, you have marketing ideas, administrative tasks galore, and lots of goals about how to organize for efficiency and success. You are an entrepreneur. You are the ideas person. You did not choose a career path that involves reading documents with a bright yellow highlighter. I get it. You didn't sign up for writing. You want to create or work with your hands. You want to be imaginative. You want to be innovative. But at the core, if your business isn't running as a business with its details in order, your creativity, imagination, and innovativeness is only a hobby, in my opinion, and will not be sustainable as a business. Alternatively, you are a numbers person who loves to track numbers, create spreadsheets, analyze trends. Again, you did not choose a career path that involves writing or creating or reading Word documents. Okay, I get it. Reading contracts is dull, and it can be a killjoy. Contracts talk about things that can be depressing. What happens if the unthinkable occurs? What happens if there is a death? What are everyone's rights and duties? What happens if there is non-payment? What are everyone's rights and duties in the event of a pandemic or the sky falls? This is not the kind of stuff that inspires greatness and light. However, without these core contracts, the longevity and sustainability of your business is in jeopardy, in my opinion. You see, a business's success is not necessarily wholly measured by the bottom line profit. A business's success is oftentimes measured by how it reacts during times of crisis and stress. When there is crisis and stress, the first question is usually, what do the documents say? These contracts give you a protocol and blueprints for how to get through a storm, a time when emotions are high, but the need to be grounded in what you agreed to when all was rational and sound. The contract should help you resolve the matter. It should help you survive the storm. If there is stress or crisis among owners of the business, you go to the core creation documents, the operating agreement, the bylaws, the partnership agreement. If there's a breach of confidentiality among key business partners and the business is in a downward spiral, you go to the non-disclosure agreement. If there's a crisis with a prominent customer, then you go to the customer agreement, or if you're in the service industry, you go to the service agreement. If there is stress among workers, then you go to the core worker documents, the employment agreement, the independent contractor agreement. What do all these things have in common? The written word. Save yourself the headache of ambiguity and uncertainty. Get it in writing. Failure to maintain core contracts can lead to the death of the business, not because you're not creative enough, not because you're not working hard enough, not because the profit margins aren't great enough, but because the business is not equipped with protocol and rights and responsibilities that see the business through the stress of crisis. This webinar is not a substitute for you sitting with your business attorney and further discovering and discussing what important contracts your specific business should use. The goal of this webinar is to increase your awareness of contracts that are available and worth considering in your business. The webinar shouldn't be taking a deep dive into all sorts of elements of each contract type. We're going to give you an overview so that if it sounds like something you would want to further explore, you know to do so with your trusted attorney. Speaking of trusted attorneys, I'm going to hand this off now to Maria, who will discuss business formation contracts.
Thank you, Mia. So just getting started with business formation, there are a lot of different options. So if you just kind of get started doing business, you don't do anything formal, you haven't filed any documents, you kind of just jump in and get started. Those are called sole proprietorships if it's a single individual that's getting started, or you have partnerships, and these are informal partnerships because there's some different kinds of those. We have limited liability partnerships that are formal entities and some variations among there. But I think the biggest thing to know is that in sole proprietorships and partnerships, something that where you haven't filed any documents and really created that separate legal entity, you're assuming all of the risk. So that's kind of the beautiful thing about creating these formal companies and starting a corporation or an LLC or some other entity that's kind of fitting to what your needs are, is that you're protecting against liability and you're protecting against some of the risk that can come along with operating a business. So just noting that kind of the big thing here is that you're going to be personally liable for all of the debts and obligations of a company. Whereas if you start these formal entities, it gives you a little bit of a shield. Starting with corporations, these are kind of, I think, the more formal entity that exists, and they have a lot of advantages, but there are also some things to be mindful of if you're interested in starting a corporation. We'll get into that a little bit as we go, but the way that a corporation is formed is through articles of incorporation. You'll file those with the Secretary of State. They come with a fee. I believe it's $100, I think, to start, but it also just depends on how many shares you want to issue. So those are things to kind of keep in mind as you're getting started. Again, you're shielded from some personal liability as long as you follow these corporate formalities and you stay in line with how you're supposed to conduct business. And like in most cases, the biggest risk is really going to be in the money that you invest, right? You take the risk that maybe the company doesn't do as well as you had anticipated, or things don't go as planned and you might suffer some losses there. But as long as you're kind of operating the way that you're supposed to and following those corporate formalities, your personal assets are generally shielded. Very similarly, limited liability companies also protects your personal assets and kind of creates this new separate legal entity. It's formed by filing articles of organization through the Secretary of State. It also does depend on what state you're in. If you're forming a company in another state, then you might have to file some different articles or different documents in order to get started and get going. Again, with the LLCs, you have this shield, right? Your assets are protected so long as you are conducting business the way that you're supposed to and in line with all of the statutory and regulatory requirements. Uh, the nice thing about limited liability companies, which we'll get into as well, is that they're a little bit more flexible. You have a lot of control in how you want to structure your business. You don't have to follow all of the same corporate formalities that corporations have to follow. So these are things like biannual reports that corporations are required to file. You have to do annual meetings and have those minutes drawn up if you're a corporation. Certain structures that you have to follow. If you'll go to the next slide, please, Mia. So getting into corporations. The Business Corporation Act is the statute that controls in New Mexico. I left the citation there. You can find the statute online on New Mexico OneSource, which can be helpful as a point of reference. The structure that corporations generally follow. They're owned by what are called shareholders. So these are the people that own the business, and then they're managed by a board of directors. These can be the same people. It depends on the structure that you're looking for. And then the company is also going to appoint officers. So these are president, secretary, treasurer, those kinds of officers who are going to run the day-to-day operations. Again, these can be the same people in certain circumstances, depending on your structure and your needs. But that's kind of how you get started there. Corporations are governed by bylaws and shareholder agreements. These are the ownership agreements that we'll get into a little bit more of the nitty gritty as we go on. But these are really kind of outlining and building the foundation for what your company is going to be. It sets out who's responsible for what. It sets out things like profit sharing. It sets out various details that are going to kind of guide how the business will operate. It provides plans for buyouts, exits, and disputes. So dealing with those things kind of ahead of the game so that when the time comes for any of those events to occur, you're prepared and you know what steps need to be taken to get there. I mentioned a little bit earlier that corporate formalities are a big piece of corporations. I think that that's really important to keep in mind, especially if you're just getting started. There's always the risk that you might run into, the failure to file annual meeting minutes or your biannual report with the Secretary of State. And that can put you out of compliance and just opens you up to some risk. You might not be able to file a lawsuit under the separate legal entity that you've created. And then you have to go through a couple of hoops to get back into compliance and to fix everything so long as you're within those timeframes. And the statutes kind of detail some of these items, but it's definitely something that you want to keep in mind as you're moving forward and if you're considering a corporation. If you'll move to the next slide, please. Limited liability companies. I'm going to spend a little bit more time talking about limited liability companies just because they tend to be a little bit more popular. That's really the bulk of what we see come through our doors when people are getting started in forming companies and even companies that are already operating. I think that the real benefit here is the flexibility that it offers business owners. Again, you're not having to follow all of those same corporate formalities in terms of like filing the biannual report, which can be something that you just need to keep track of. So if you stay organized, not a big deal. You can definitely, it's feasible and has a lot of advantages. But LLCs tend to be a really good option for people. They're relatively new, and I say that New Mexico adopted the Limited Liability Company Act in the 90s. So that's kind of when that got started here. I think in Wyoming it was like the 70s. So it sounds a little bit of a while ago, but relatively new. Again, I think that the biggest thing to really emphasize here is that liability protection, and then limited liability companies in terms of like forming them and getting started. They're owned by members. That's the same name as shareholders. That's what we call the owners in limited liability companies. There's different ways that you can structure them. They can be a single member where it's just you getting started, or you can have a multi-member LLC. Something to note here too is that in New Mexico, a married couple can form a single member LLC. It would be the husband and wife forming as a married couple. So that's something to note. and then manager managed and member managed companies. So these are really beneficial because, again, that flexibility and structure. So sometimes you might want to just say, I'm getting started, it's my business, I want to see where things go. Maybe you're just kind of feeling it out, or you have a trusted group of people that you're working with, and you're like, everybody has the same authority. We can all kind of do the same things. We'll just keep it member managed. Whoever is a member can manage the company and act within a certain scope of authority. On the other hand, you have manager managed companies. And when it comes to manager managed companies, you can say, we're going to designate certain managers, and they're going to have a certain scope of authority that would be set out in the operating agreement. This is really beneficial for family businesses. Sometimes parents will get a business started and then they want to appoint their children to have certain authorities, to kind of pass that on. And as they grow in the business, as they learn more about what's going on, then their scope of authority can adjust. Sometimes people want to introduce key employees, and this can be a really effective way to do that, to say that somebody has signing authority maybe for a $5,000 contract. Anything over and above that amount needs certain additional sign off or a meeting or something else like that. So lots of benefits that come with that. Limited liability companies, they're going to be operated or governed by operating agreements, excuse me. They're not required. These don't get filed with the Secretary of State or anything like that. It's really just kind of your handbook about how you're going to handle the company. So how are things going to go? Who, again, is responsible for what? How are profits going to be distributed? Sometimes you have different ownership shares. So somebody might own 60% while the other partner owns 40%, different things like that. Again, similar to the bylaws and shareholders agreements, it's going to address things like these big life events, death, departure, or disputes among members, which unfortunately do come about. And it's really important to address these things as you're kind of getting started. And then moving on, they can also, operating agreements can be required by banks or lenders and investors to kind of have an idea of how the company is run, gives them an idea of the foundation and the structure. We often have clients who come in and need some kind of documentation to take to a bank and say, I'm the owner of this company, I need to open an account, and things like that. So they're really good to have. It's really beneficial, even though they're not required. They can really come in handy as you kind of move forward in conducting your business. You'll move to the next slide. So getting into ownership agreements, they are kind of similar. So I'll talk about them in kind of a general scope, because really at its core, an ownership agreement is going to cover some of the things that I've already mentioned. Who owns what percentage? So again, you might have a 51% owner and then a smaller breakdown for some various owners, depending on who's bringing capital, who's bringing expertise, different things like that. You're going to set out the rules and responsibilities. I mentioned manager managed companies. This is a good place to say, again, this person has authority to act in whatever scope. Maybe you're working with somebody who has a certain expertise that you don't. We have construction companies come in, and sometimes there's a party that has just a really nuanced and a really great expertise in painting, for example. So they might take on those. Another partner might have an expertise in electrical work, so they'll take the expertise in that, and you can really delineate these roles and responsibilities within the ownership agreements. Again, addressing how decisions are made. Do you want to have a meeting? Do you want to allow certain actions to take place without having a meeting or without requiring certain authorization? You can kind of detail those items within the ownership agreement. How profits and losses are split, whether that's going to be according to the membership interest that you own, or if it's going to be some other split based on the nuances of the business and the details of your operation. Buy sells are really, really important. I think that this is probably one of the biggest reasons to have an ownership agreement, is to really just know what's going to happen if a partner wants to leave. Say they're moving the state, say that they're going to venture off and create their own endeavor and start a new business, do something different. Maybe they need to sell their interest, and you want to detail how that's going to happen, whether you're going to bring in a new partner or if you want to set certain restrictions and give yourself the option to buy back interest before that happens. I'll note that I recently had a client, we were in the middle of reorganizing their business. One of the partners had a stroke. And so now we're having to navigate that because they had an operating agreement, but unfortunately it didn't address what happens in cases of disability. So now we're having to kind of put the pieces together and figure out what needs to happen next in order to ensure that they can kind of continue operating, continue with the reorganization that they had established, and things like that. Lastly, I have listed here how disputes are going to be resolved. This is really important too. Litigation is so expensive. Our firm is not actively doing litigation at this time, but I will say that it can be stressful. It's very time consuming. It's expensive monetarily. So I think that, providing for whether you'd like to go into mediation or arbitration are really great alternatives. And if you set that out at the start, then it's not something that you have to worry about later. You're not worried about where partners are going to go and choose different things, or if somebody does want to go to litigation, that can be some unexpected incurred costs. So you want to just be very mindful of that. And I think that it's also best to just deal with it before things go wrong. So really stepping in front of it and saying, let's try to anticipate what could potentially go wrong. And while things are good and nobody's stressed and, tensions are really even, and, we like to say that sometimes businesses are in the honeymoon phase of things, and it's a lot easier to deal with those uncomfortable topics like breaking up a business when things are going really well. And then it kind of it alleviates some of that stress that might come up later. I'll note a couple of things here. I think that some of the common mistakes that we see come in a lot are that people, one, don't have an ownership agreement at all. And then you kind of leave it to the statutes, which are pretty scant. You're not going to have a ton of information there, and that can create room for lawsuits or disputes that are pretty uncomfortable and not great. Another thing that we run into, and I think is going to be very common again, is using online templates or even ChatGPT, AI. I think that these are really great tools and they can be really useful, especially when you're getting started. But you just want to be careful that it's applicable here. So you want to be careful that it's following the law in the state that you're in. So you want things to be tailored to New Mexico law. It might be a little bit different than California or Washington or New York or things like that. So something to be conscious of while you're looking through online resources. Another thing to note is going to be updating the agreement. So as you progress, as you move forward, your business might grow, you might bring in new partners, but you might forget to update your ownership agreements. And again, for all of the reasons that I've mentioned, they're really helpful to have. You want to make sure that you have updated documents. And then also, as I briefly touched on earlier, just avoiding those tough conversations. I think that it's best to have them early on to get all of those details sorted out so that whenever something does happen, it's easier to deal with. It's a little bit less contentious. You can just look at the document and say, we know how to deal with this. And, you're obviously going into business, so you have good relationships with your partners, and transparency is key. I think that it's just really helpful, and getting all of the details sorted out so that you know how to deal with things as you move forward. So highly encouraged, not required, but definitely something to keep in mind as you're getting started. And then I'll go ahead and pass it back on to Mia. Oh, sorry. I think you're muted.
Thank you. Sorry. Yeah, talking about stress, avoiding litigation, that is a really good segue into what I'm going to talk about, which is customer agreements. On the helpline, I help a lot of people who, for one reason or another, have to get into litigation and they don't have any written customer agreement. So this is a topic that is near and dear to my heart. Do you think, this is a rhetorical question, that oral, spoken, verbal agreements are enforceable? In many cases, they are. So why put something in writing? Because when a contract is only spoken, the details that protect you are not in existence. When a contract is only spoken, and when a disagreement happens, you are at a disadvantage because you have to argue against the he said, she said. This is difficult. Courts are less likely to enforce when things are not clear. When a contract is only spoken, and if the complaint begins years after the contract is made, everybody's memory is fuzzy. Memories fade. When a contract is only spoken, things are misunderstood. People remember differently. When a contract is only spoken, someone trying to take advantage of you and make fraudulent claims against you has an easier path to do so, in my opinion. A liar likes oral contracts. A criminal likes oral contracts. When a contract is only spoken, the requirement for somebody like your customer to consciously deliberate and think carefully before entering into an agreement is nil. You could end up with an impulsive and non-committed action that falls through. When a contract is only spoken, you look less reliable. The days of the handshake was great. We do not live in those times anymore. I'm sorry. You must protect yourself. You must protect your customer. Truly, it goes both ways. When a contract or something is in writing, you are not only protecting yourself, but also the customer. Be the business that cares. Get it in writing. Does the writing have to be huge? No, it does not have to be huge. Can the writing be automated? Put in a template form for use over and over? Absolutely. Spending time on this now can make things streamlined in the future. Now to discuss some nitty-gritty, so I can show you how this is not Herculean. It's not insurmountable, and you can do it. We will discuss like a sales agreement if you are selling a product, or a service agreement for a service. But first, I need to get you into the mindset when you're doing this. You are drafting or creating this agreement with the worst and most rude customer in mind. You may say, I don't help rude customers. You may say, I send rude customers on their way. I don't accept them. I get that. I used to do some of that. I say, that's great. However, people are funny. Imagine you signed up the nicest customer you've ever met, and you're thinking, gosh, I could hang out with this person. That's so great. Okay. You enter into an agreement with that person, service agreement. Within a month, that person has turned into something your worst nightmare could not imagine. You see, you have to draft these things with the worst and most rude customer in mind and use it across the board, even for the nicest people ever. Okay, so now that you're in the mindset, let's get into some details. I've got this as the top 5. There's so many things I could have fit in here, but I reduced it to 5. Let's say you are in the business of providing a service, or you are in the business of selling a product. Here is a core top 5 list. The first thing that I look for when I analyze a contract, a service, or sales agreement, and therefore the first thing that I think you should look for when you're doing this, is the exact opposite of what I think you're thinking I'm going to say. I want you to find out if you have a clear way out of this contract. Is there an exit strategy built into this document? Certainly the contract should have a beginning and end date of the term, but you also need to look for conditions under which either party could terminate this agreement. Again, imagine the most rude, worst customer ever who is siphoning your employee's time and therefore your money, and you have to put an end to it. Is there a termination clause in the contract that allows you, as the provider, to bow out gracefully? If so, what is the notice requirement? Must it be with cause? Could it be without cause? If you terminate, are you going to owe them money? If you terminate, do they owe you money for work done up to that point? What is best for your situation? The next most important item, I think, is to discuss payment terms. in your written agreement. On the helpline, I get calls from small business owners who are owed money. They provided a service, invoiced the customer, not paid. They are facing court to enforce rights and hopefully get paid. Therefore, we need to talk about defining payment terms and payment due dates. Include specifics on fees, the payment schedule, methods of payment. Include what happens if there are late payments. Maybe a statement saying that if payment is not received when due, you're going to stop work. On the helpline, I have talked to business owners who are owed thousands of dollars. These fees accrued over a period of months. They were not paid for months and yet continued. They kept digging the hole deeper and deeper. There was no mechanism built into the agreement that allowed easy termination in the event of non-payment, and the owner kept working, thinking that ultimately all would be made right. So the lesson there is to have a payment schedule and a policy clearly written in your contract, and also to make sure there's someone in your office who's going to enforce it. See, it may be hard if you're the owner worker. It's hard to internalize the fact that you're not getting paid and that you must therefore stop. Your work is valuable. The customer needs you. You have a strong work ethic, so you continue. But someone needs to stop that centrifugal force that is holding you in that work pattern and instead cause an accounts receivable force to take over at some point in time. You should not work for free. Most of the time, clearly stating the consequences for failure to pay, whether it's a late fee or stopping work, is reason enough to get a person to remember to pay. It's when things are not written or not clear that a person thinks they have leeway and they can take advantage. Warranties, disclaimer of warranties, refunds. This is another subject that comes up on the helpline, is warranties or guarantees issued in connection with services performed or products sold. If you intend to give a warranty for your service or your product, have that warranty clearly described very specifically and in terms of what you know you can and will do. By being vague or ambiguous or simply not stating anything at all, you are subjecting yourself to possible warranties that are implied in the law. You see, there is a whole section in the statutes that talks about whether or not implied warranties are granted when nothing is stated. So by not saying something in a contract about this, you could very well be actually granting many more warranties than you ever dreamed. Again, saying nothing about warranties most likely means that you are granting warranties under the law. The next big thing is the obvious, the scope of services. What are you doing? What is going on in your contract? What are you providing? What is the service? And it seems like when I see contracts on the helpline, it's like sometimes it's just not worded well. And this is what you do. You need to figure out a way to describe what you are doing and put it in that contract. This is your business. This is your bread and butter. Figure out how to explain it in a way that clearly describes your function. And when I think it kind of comes down to these sort of Dr. Seuss questions: when, where, what, how, and who. My next slide is all sorts of nitty-gritty, but if you remember when, where, what, how, and who, and that is described when you're describing what you're doing, you're going to be in pretty good shape. Okay. Here's a really nitty-gritty slide. I said I wasn't going to get into too many weeds, but here we go. A service contract. When will the services be done? Where will it be done? What will be done? How? Does a crane operator have to be there before you can do what you've got to do? Who is going to do the work? When you're selling a product, when is the product going to be delivered? Where will it occur? What is it that you're actually doing? How is it being delivered? So you can read that slide. So again, it's the when, where, what, how, and who. Just remember Dr. Seuss. And again, there are probably ways to draft descriptions for repeated use. So figure out how to describe what you're doing in writing. the when, what, where, how, and who. Figure out a way to reuse that description when it's suitable in the future so you're not constantly reinventing the wheel. Okay, and the last top 5 thing to make sure is in your agreement, and this is like so obvious, but you have no idea. Identification of parties. So if you listened to the last webinar we did in February, you heard all about how the use of your corporate or LLC name is very important. Make sure you are signing and holding yourself out properly to avoid undue personal liability. The other thing you want to make sure about is that the name of your customer is correct. For example, I'll never forget the case where a client of mine entered into a pretty big agreement with a corporation that didn't exist. He had done so much work in reliance on that contract, and the corporation that he entered into a contract with did not exist. In other words, that corporation was not registered with any Secretary of State's office. So my client basically had a contract with nobody. Of course, that client came to me when things went south. I had to be the messenger on that terrible news, and we did figure out ways to deal with it, but it was super, super difficult. Here's another example of why it's important to verify your customer identity. Let's pretend you're involved in a service that provides landscaping services or heating and air services or cleaning services, and you enter into a contract with a person who's living at a certain residence. I certainly hope you're entering into a contract with a person who is the owner of that residence. And if they are not the owner, then how is that person authorized to allow work to be done at the place, such that if there is failure to pay, you actually have recourse? There are ways to check public records. There are ways to understand who owns what property. And when you're doing your contract, make sure you have an accurate customer name who is verified. And the last thing on that is email is great, but when you want to sue somebody because they've breached the contract, you need an address. You need a real address. So sometimes that can be challenging for my clients on the helpline. They don't have addresses. They have email addresses. You can't serve anyone on an email. So get a good mailing address. There are other items that are appropriate to include in your agreements. I tried to give a sense of the most important and overall convince you to put it in writing. Now I'm going to hand it over to Maria for non-disclosure agreements and worker agreements.
Thank you, Mia. And actually, I just wanted to add one quick note also, now that you were speaking, it reminded me another thing to kind of just be cautious of as you're moving forward in operations and getting started in your business is this notion of piercing the corporate veil. Some of you may be familiar, but it's really important to just make sure that you're maintaining clean books, that you're not commingling funds. It's sometimes helpful to engage a tax expert or a CPA if you have that capacity to really make sure that you're keeping that delineation between the company as its separate legal entity and you as an individual, right? Like you're signing on behalf of the correct company and you're identifying the company and not yourself as a signer. So you can sign on behalf of the company, but you don't want to bind yourself personally to that contract. So something to just keep in mind as you move forward. And we love everything in writing. It's always so much better to have a document to reference instead of an argument of he said, she said. Moving into non-competes and non-disclosures and non-solicits, a lot of the same things, right? Keep it in writing, and also just maintain clarity. It's really important in terms of enforceability and getting these contracts to really stand up in court if it does come time to really make sure that they're enforced, or if you need to bring an action or something like that, you want to have something that's clear and something that's enforceable. So kind of just a brief description of all of these agreements. You may already be familiar with them to some extent. Non-disclosure agreements are generally one of the most popular that we see, and these are really to just protect your confidential information as your business. Pricing structures, your client lists, any special, sometimes recipes. If you're like a restaurant or a bakery or something like that, those are things that you can protect using non-disclosure agreements. And these can be used in different capacities as well. They can be used in the employment context. They can be used in independent contractor context. They can also be used in the context of sales and purchases of companies. So sometimes you might enter into negotiation to either purchase or sell your business. A non-disclosure is a great tool to utilize so that you can make sure that you're protecting your company's information if for some reason that transaction doesn't go through or something like that. Non-solicits, also a great tool to use. You can use them in the employment context. They're really beneficial, but you can also use them in customer agreements. So I'll give you an example. One of our clients does some construction work. They're a contracting company. They do a lot of work for various apartment complexes. So their employees go out to do a project, they're paid whatever wage, and then the apartment complex is looking for a new maintenance person. So they might throw it out there like, we'll pay you at this rate and you can come over and work for us. That might be a lucrative deal. But of course, you want to protect your investment in the people that you're hiring to do your work. So you can actually build it into your contract with the apartment complex and say, by hiring us and utilizing our services, you agree not to solicit our employees. The same is true in reverse. So you hire on these employees or independent contractors, they venture off and they're no longer doing work for you. Well, they said, we know we did work for this person and they pay great rates or something like that. So let's go see if we can pull some of these clients that are clients of this business that we used to work for. Having agreements in place to prevent that from happening is a really great investment for your business. Moving on to non-competes, I will caution against non-competes. The legal landscape around non-competes is evolving very quickly, and courts tend to disfavor non-competes just because of the restriction on work, right? We want to make sure that people have the opportunity to go find jobs where they can if they're specially skilled. We want to make sure that the economy is moving forward and that we're not restricting anybody's opportunities. Although there are some contexts where these are enforceable, they're very valuable. So we'll kind of just dive into these a little bit more, starting with non-competes, just because I just mentioned them. I noted on the slide to watch for FTC updates. This is the Federal Trade Commission. They proposed a rule recently that's been kind of going back and forth with how it's going to work, and this was a proposed ban on non-compete clauses nationwide. Again, this is kind of focusing especially for employees that fall below a certain income threshold. The rule has not been finalized, but it really does highlight this skepticism that courts tend to have around non-competes. So while they can be a really great tool to kind of limit people from going and starting competing businesses and using some of that proprietary information to do so, you want to use them with caution, and also keep in mind these alternative agreements that might still protect that same competitive advantage, but through a more enforceable manner. If you do choose to use a non-compete, you really want to be cautious of the time scope. So how long do you want somebody to be restricted from competing against you? Is it a year? Is it 2 years? Is it 3 years? It's going to be a little bit dependent on the industry as to what a court might find to be enforceable. A year is pretty safe in most contexts, but it is going to depend a little bit. The other thing you'll want to keep in mind is the geographical limitation. So within what radius do you want to limit people from competing against you? Sometimes it's appropriate to say 50, 60, 100 miles. Sometimes it's appropriate to say within the state. Again, it really depends on the industry and the nature of the business. You're going to think about like whether you're in a rural area, right? Is somebody going to have to travel 150 miles to find gainful employment because their employment didn't work out with your business, or vice versa, right? If you're going to seek to start your own business and you might be thinking about whether you're subject to a non-compete, think about those terms that a court's going to consider in determining enforceability. The last thing I'll note there is the scope. So you want it to really be very clear about what role the person had within your company if it's an employee that you're trying to enforce this non-compete with. Is it a sales position? Is this person going to be limited from any kind of sales, or are they going to be limited within tech sales, for example? So just different things to keep in mind if you do want to implement non-competes within your business. Then moving on, we have non-solicitation agreements. I mentioned those. A lot of different uses, again, can be really useful in protecting your competitive advantage. These are going to be focused on either employees or contracts or clients. You don't want somebody poaching your clients and customers. And you also don't necessarily want somebody that's recruiting your current employees that you've spent a lot of time, resources, money, training, and making sure that they get some really great skills that make them essential to your business. Non-solicits, as I mentioned, do tend to be more enforceable in most cases. Again, be specific, be limited in time, think about really what's enforceable and what's going to be reasonable in front of a court. And then you're going to also want to note for all of these, an important element is consideration. So when are you having people sign these agreements? You can have them sign when you bring them on as employees, and if you're doing it as part of the onboarding process, then their consideration, which is the benefit that they're getting, they're giving up something, right? So whoever is signing into these, whatever party it may be, whichever side of the agreement that you're on, you're either giving up something or you're gaining something. So if you're going to have an employee sign this agreement, they're giving up certain things, right? They're agreeing not to go compete against you. They're agreeing not to take part in these certain competitive behaviors. And in compensation for giving those things up, they need to either get employment. That can be a form of consideration. If they're already an employee, you can offer additional benefits packages or a bonus or a promotion. Those are all really great options to use as well. And then finally, I'll just touch on non-disclosure agreements a little bit again. These are going to protect those documents and your practices, these proprietary, the proprietary information that really is unique to your business and that you want to protect to hold on to that competitive advantage. And a couple of items to note here. You're going to want to clearly define what is included as confidential information. Again, you run into issues all the time. We had somebody trying to enforce a non-disclosure, but there was a very explicit exception for any information that was generally available to the public, which this case happened to fall into. So those are things that you'll want to be careful of, is how you're identifying what qualifies as confidential information. Maybe it's a recipe that you want to consider confidential information, but if that recipe has been posted by the business online, that might not be considered confidential information anymore because it's just generally accessible. So think about how you're protecting confidential information. And again, timeframes is another thing to keep in mind. How long does this information need to be kept confidential? One additional item to know, with any of these agreements, they can either be standalone agreements or they can also just be terms that you weave into other agreements. So we just talked about employment contracts. You can weave all of these into your employment contracts and do it that way, or you can introduce standalone agreements if, for example, you've already implemented employment agreements or you just want to do something separately. That's also an option. Just again, I would caution against using online templates, being very careful that they're state specific, that you are, tailoring them to your business, to your industry, things like that. Noting consideration, that's a really important thing to think about depending on when you're implementing them. And the scope, make sure that your scope is reasonable and that you're not trying to implement something that's not reasonable, that a court might not find enforceable. And the same is true if you're bound to any of these kinds of agreements. Think about the same, right? Is it a reasonable restriction on what you've agreed to, or is there some pushback that you can kind of find there? And ensuring that everything is clear. Language is so important. Mia mentioned, we love to highlight our documents and we're looking for all of those special words and keywords to include and make sure that are implemented so that we can protect our information, so that you can protect your employees, so that you can protect your business and your processes, your client base. It's just a lot of safeguarding that value that your business has. So when possible, I would encourage you to work with a lawyer, but really just try to inform yourself and educate yourself with whatever resources you have available. And with that, I'll pass it back to Mia. Oh, no, I'm sorry. This is still me. Moving into employment and independent contractor agreements. Mia has already touched on this just a little bit. I want to emphasize this is not just a paperwork issue. So agreements are helpful, and we've been saying that it's really great to have everything in writing. However, There are certain cases, as in the case with the distinction between employees and independent contractors, where it's really important that the actions match the words. So when it comes to independent contractors, you might bring somebody in and say, this is the structure that I want, and you might classify somebody as an employee or as an independent contractor. There needs to be really just pay attention to the granular detail, because if you have a great independent contractor agreement, that's awesome, but if the relationship does not match the terms of the contract and the nature of the relationship is lending itself more to an employment relationship, the court's going to find that it's not an independent contractor agreement, or it's not an independent contractor relationship, and that can create some issues in terms of like IRS audits or fines and penalties. Department of Workforce Solutions might step in and have some concerns for like back pay of wages and benefits and things like that. So really the key difference here, and the thing to keep in mind, is going to be control. How much control are you exerting on the people who are conducting work for your business? If you are determining their work schedule and they have to clock in from 8 to 5, and you're providing all of the materials for them to get their job done, if you're restricting them from taking on other clients and working for other businesses, then these are all things that might lend itself to a determination that it's more of an employee relationship than it is an independent contractor. So the less control, the more it looks like an independent contractor agreement. If they can set their schedules and work for other companies and do other things, then that's an independent contractor. There are multi-factor tests that are going to come into play, and if it ever becomes a question, they look at all of the elements. Not one is determinative of the other, so you really just want to make sure that the whole picture is in line with what it should be. Again, as I kind of briefly mentioned, there are some things that it becomes an issue because employees are entitled to minimum wage. They're entitled to overtime, workers' comp. You're going to have to get different kinds of insurances depending on whether you're working with independent contractors or employees. So these are things that you want to keep in mind. And again, just noting that the contract in this case, while it's really beneficial and it can help and it's a factor of consideration, it's not going to be determinative. So just make sure that you're keeping in mind these different items: scope of work, how they're being paid, tools and expenses. So as a couple of examples, the scope of work. So what exactly is this person going to be doing for you? When is it due? What's the timeline? Things like that. Payment terms. Is it fixed fee? Is it hourly compensation? Hourly compensation generally lends itself more to an employee relationship. Tools and expenses. If they're using their own tools, that's more of an independent contractor relationship. If you're providing all of the tools and resources, then that's more of an employee relationship. So some different things to keep in mind, but all very much worth noting and kind of protecting yourself and being careful of misclassification. So make sure you know that difference and that you also act accordingly.
And a nod to the next one where Attorney Taylor Duffney is going to take us into more specifics on the difference between employees and independent contractors, right?
Yes. Yeah,
And
Taylor
then-
is another attorney here at our office, and she has a really great nuanced expertise of employment and independent contractor relationships. So it'd be a lot of useful information.
The
Great.
next one, you mean the next webinar, right? Which is June 7th.
Next webinar, June the 7th. That's
June
right.
4th. June 4th.
June the 4th. We are May 7th, June 4th. Yep. Okay.
I just wanted to give a 5-minute warning, ladies.
Yeah. So I was going to do a little talking about lease agreements. Those to me are pretty important agreements. And I think it could very easily be a topic for the future, like take up a whole hour. So I'm going to put it down in like 3 minutes, what I'm going to tell you. I'm going to give you some examples that I've come across in the on the helpline. Well, and in private practice too, when I was in private practice. It is amazing to me how many businesses operate their business in a place that they rent, yet they have no official written lease agreement. It's a thing, you know? I see all the worst case scenarios. Lawyers generally see the worst case scenarios, especially when there's no written lease agreement. Here's an example. Landlord dies. Tenant is locked out of the building where the landlord and the tenant sort of shared some business space. You see, the landlord owned the building, let the tenant operate out of the building. Landlord also had a little business he ran out of the building. All of the tenant's tools and equipment of the business are stored in the building. The long lost relative of landlord, who's now in charge of the building, denies tenant access, denies that tenant is the true owner of any of the tenant's stuff inside, and it's just a nightmare. Another example I have seen, landlord, owner of a building, again, no written lease, declares bankruptcy, and the tenant is locked out of the brick and mortar building where her business operates. The bankruptcy court won't deal with that tenant until a lease is in writing and signed. Nightmare. Another one I've seen, landlord fails to pay some taxes. The tax authorities descend on the building and literally padlock it. And the tenant is like, wait a minute, I'm a tenant here. And they're like, well, you need to show us your lease. And you might think that proof of payment, like of rent every month, is like proof of a lease, but I'm telling you, it's not always the case. So at this point, so the little leak thing going on in the slide is one case where I had, and I've had a few of them like this, you know, landlord is supposed to fix the roof. That's the landlord's, remember, no written lease. Landlord's taking care of the roof. Monsoon comes. All the stuff inside is ruined. Landlord says, I wasn't going to take care of that roof. It was never part of the deal. Says it was your responsibility, tenant. Then the tenant also says that the landlord's insurance was supposed to cover his stuff, you know. And of course, that's a whole other topic. That's never the case. Landlord doesn't have insurance to boot. So the tenant is just in a horrific situation. Without those kinds of details being in writing, being able to bring a lawsuit, let alone be successful in that lawsuit, is severely, severely diminished. So getting it in writing is very important. In the commercial lease context, it is the wild, wild west. We don't have, you know, in residential lease context, you've got all these protections of the tenant. You don't have that in commercial lease. So especially as a tenant, if it's not written in there, you've got to presume it's going to be on you. And I guess we're out of time. And were there any questions that came in? Okay, great. Well, we hope this has been beneficial and helpful. I know we're stressing getting things in writing, and that's not everybody's forte, but maybe, you know, give it a go. Okay.
Thanks everybody for attending. You can find our webinars that we've done in the past on the State Bar of New Mexico's website, sbnm.org, and look for the public tab, and the Modest Means Helpline webpage within that tab has, as on our publications page, it has all of our past webinars, so you can peruse them at your leisure. We appreciate everybody attending, and have a great day.
Thank you, Maria. Good job.
Yeah, thank you, Maria.
Thank you.